all this I'll call this hearing back to order, and this afternoon we're going to hear closing submissions from counsel for the two parties. Unless there's anything else before we want to get started, I would invite Ms. Becker-Brooks to commence.
Okay, sounds good. Thank you, sir.
Actually, before you do that, I do know, I heard you, Mr. Wilson, indicate that you did receive a copy of a transcript.
You're muted.
Yes, I received the transcript of Elvira Thompson, and just thank the court reporter for that. And we will, in communication with Ms. Becker-Brooks' office, we will be getting you regular transcripts of all 3 days in the ordinary course, 10-day delivery.
Okay, on that point, I'm not sure how it works in terms of timing, but for my purposes, I certainly don't need a certified transcript. I'm happy with a draft transcript. And I don't know if it's if that would shorten the job for the court reporter and lessen the expense for all of the parties, if they're just draft transcripts as opposed to formally certified. Are you able to give us any information on that, Colleen?
It would shorten the time, and it would shorten the expense as well, definitely, yeah. How soon were you looking to have them for?
Well, I'm thinking as soon as possible, because I mean, this raises the question of the timing that I need to be aiming for in order to issue an award. And working backwards from the April 1st deadline by which the parties need to have the ICF agreement in place and presumably passed by bylaws, I'm thinking that I'm going to have this award out no later than mid-January.
So if I was to get it to you mid next week, would that be okay?
Yes.
Okay.
That'd be fine. I guess I wasn't really answering your question. Council, any thoughts on that?
So long as it isn't going to cost more money, I'm fine.
I'm fine with that as well. Actually, my clients asked if I had an idea on when we could expect a decision from you. So you read their minds on that and gave a bit of a ballpark, which I think is helpful for them. So.
Yeah. Okay, so yeah, Madam Court Reporter, certainly mid next week would be fine. I didn't have anything to do over Christmas anyway. So thank you for that. Ms. Becker-Brooks, would you like to start?
Okay, thank you very much, sir. And thank you for accommodating the change in schedule in that we managed to be a little bit done with our evidence. And so that Mr. Osmond could be here today. I made sure he was in the screen so you'd know that he was actually here. So the town and the county are municipalities that share a common border, and therefore they're required to create an intermunicipal collaboration framework, and that's pursuant to section 70828 of the Municipal Government Act. And a lot of the statutory provisions, of course, are set out in the written submissions of both of the parties. So I don't plan to take you through those numbers today. Please refer to the written submissions and to the rebuttals for specific references to the sections of the Municipal Government Act. Simply put, an ICF is a tool that has been mandated by the provincial government through the Municipal Government Act, which is intended to facilitate and encourage cooperation and cost sharing between neighboring municipalities. And the reason for that, the underlying purpose, is to ensure that we have municipal services that are being provided to residents as efficiently as possible. The town and the county have a number of agreements in place with respect to intermunicipal services, but recreation and culture and the ECDC are the two areas where they have been unable to come to an agreement. In the big scheme of things, this isn't bad. I understand that Whiteport and Woodlands County arbitrated 13 different service areas. And that's quite an undertaking. I think we would all agree on And while we have heard the last couple of days a lot of testimony about differences and frustrations between the two municipalities, we've also heard testimony about councils working together, about the mayor and the Reeve reaching agreement on important issues, and on the Recreation Board moving forward with its mandate. So we've heard positive things as well. The goal of an ICF agreement, which we'll have to keep coming back to, is that it's a collaborative approach to intermunicipal service delivery, which provides for integrated and strategic planning, delivery, and funding of services, and the efficient use of those scarce municipal resources we've heard a lot about, and also which ensures that municipalities contribute funding to services that benefit their residents. So those are the fundamental purposes of an ICF and what we really have to keep coming back to, and not go down roads that don't help us actually achieve that goal. So the issues today that are before you aren't really concerned with the delivery of the services because the evidence doesn't reveal much in the way of the duplication of services or gaps in services. We don't have a situation where two municipalities are providing the same services, and that's a relevant consideration. The issue before you today is the fair and equitable contribution of a municipality, well, both municipalities, towards intermunicipal services. And really the key issue is fair and equitable contribution towards intermunicipal services provided by the town, which benefit county residents. It's the town's submission that a truly collaborative approach to the delivery of intermunicipal services must recognize the mutual benefit of those services to neighboring municipalities and the accompanying expense of providing those services. The town of Drayton Valley and Brazeau County were unable to agree to an ICF by April 1st, 2021. And of course, that was an extended timeline by a year because of COVID. But they also weren't able to agree to it by April 1st of 2020, obviously. They were therefore directed to arbitration by the minister for the purpose of generating an ICF addressing these intermunicipal services. The town's position is that cost sharing on intermunicipal services should be based on benefit. And that's supported by the relevant provisions in the Municipal Government Act. And it's the town's position that use of those services and access to those services is the fairest measure of benefit. With respect to the recreation and culture facilities, it's the town's position that the county's contribution to the operating shortfall should be 50% of the operating shortfall for the recreation and culture facilities that are identified in paragraph 10 of the town's written submissions. And that's the Omniplex, which includes the two arenas, the 6-sheet curling rink, and the fitness center. It's the MCC, the Mackenzie Conference Center, Park Valley Pool, and then all of the outdoor facilities, including baseball diamonds, soccer and rugby pitches, splash park, skate park, tennis and pickleball courts. And then the new swimming pool will replace the existing swimming pool in 2022. The proposed contribution of 50% is based on the historical approach of the parties, and it's based on the percentage of the residency of students enrolled in the schools. And that percentage split had been determined a number of years ago by the parties to be very close to 50-50, and we haven't heard any evidence that that's no longer representative of the school populations. The percentage split of the total populations of the two municipalities is also very close to 50-50. With the county actually having a slightly larger population than the town. The county obviously has concerns with respect to the town's operation of the two arenas within the Omniplex. These concerns have existed since at least 2016 when the Farmer Municipal Inspection Report was released. The existence of those concerns isn't disputed. We're not disputing that the county has had those concerns for a long time. But it also can't be overlooked that the town is just as concerned about its own operating costs. So this isn't a situation where the town doesn't really care how much its operating costs are. The town is concerned about all of its municipal operating costs, including recreation and culture. Both council and administration with the town are well aware that they are accountable for the use of taxpayer dollars, and efforts are constantly being made to find efficiencies, cut costs, generate new revenue. It can't be overlooked that in the end, town council also has to be comfortable with covering 50% of the operating deficit for the recreation and culture facilities. It's the town's position that the Omniplex and the two arenas are being operated in a responsible and efficient manner, that any comparables that were relied upon by the county to demonstrate inflated operating costs are not comparable, and cannot be used to determine what the town's costs ought to be, or to determine what the appropriate level of contribution by the county ought to be. The town also takes the position that if there are any deviations in operating costs from comparable facilities, those can be and have been explained. The county submits that they asked for more information to explain why the operating costs for the Omniplex were so high and they were stonewalled. But the evidence that we heard over the last 3 days doesn't support this contention. Yes, the county repeatedly expressed concern about the operating costs, but county representatives, despite the process available to them through the ad hoc committee and the recreation board, did not make any requests for the information which were denied by the town. When Colin Swap asked Jen Fancy for the detailed transaction level financials in early 2020, they were provided right away. In any event, past failures to share additional information, if those failures existed, not only went both ways, but were also completely irrelevant to the question of what the actual cost to provide recreation services is and what is a fair and equitable contribution to those services by the county. Any past failures to share additional information, again, if those failures exist, which is disputed by the town, can be addressed through the sharing of quarterly transaction level financial reporting and a robust dispute resolution process being made available to either party. I think it's important to remember that the obligation to pay doesn't arise until the following year. So when the town submits that quarterly detailed transaction reporting is sufficient, there isn't any need for that to be done on a monthly basis. And we'll get into that more as we carry on. With respect to the Early Childhood Development Center, the ECDC, the town's position is that the ECDC is clearly an intermunicipal service as it provides services which benefit county families as well as town families. And the county's contribution to the operating shortfall should be calculated based on the average percentage of the residency of children enrolled over the previous year. Okay, so to go back to the roadmap that I identified in my opening statement, the issues before you today, generally speaking, I believe, or I submit, are as follows. What services are included? Recreation and culture facilities are included. Parties agree on that, but it remains to be decided if ECDC is included. Next, are the operating costs reasonable? In our submission, this question is limited to Omniplex 1 and 2, or the 2 arenas, depending what document you're referring to. But Mr. Chambers confirmed that the county is not disputing the quantum of the operating costs associated with the MCC, the fitness center, the Park Valley pool, and the outdoor facilities. No evidence was provided with respect to the operating costs of the ECDC, aside from that put forward by the town. And no comparables were provided for any of the, for the MCC, fitness center, Park Valley pool, or the outdoor facilities. What is it? And then the next question, well, I guess there's 2 more here. What is a fair and equitable contribution from the county for the intermunicipal services which are included? I think that's really the crux of the arbitration. What is fair and equitable in the circumstances for the services that county residents are receiving that the town is paying for? Now, what is fair and equitable may be different for the recreation and culture facilities and the ECDC. What is fair and equitable may even be different for each of the facilities included in the recreation and culture facilities. There's no reason that you need to land on one number for all of the facilities. A few other more technical issues, I guess, we'll need to deal with as well at the end. And that would be matters which would be addressed in the ICF agreement, such as the effective date and the term of the agreement and the required level of financial reporting, plus the cost of the arbitration. So I'll start out with the ECDC because I think it's pretty straightforward. You previously decided that you have the jurisdiction to consider and make orders with respect to any issues in dispute between the parties related to ECDC and its inclusion in an ICF. So that decision was previously made. So what you have the jurisdiction right now to determine is not only to what extent the county is required to contribute to ECDC as part of an ICF, but whether it's included at all. The county's position is that the town's operation and funding of the ECDC is not an intermunicipal service, and as a result should not be included in the ICF, and does not then, as a result, attract cost sharing. As I understand it, the county's position is that the ECDC is not an intermunicipal service because childcare services are not services that one would usually expect a municipality to provide, and that the county has chosen to contribute to childcare options in the region by directly supporting day homes. The county has also submitted that it's never contributed to ECDC in the past. Now, the evidence did demonstrate that the town that the county did pay money to the town for childcare services. The evidence was that that went directly to day homes as opposed to the actual childcare center that we visited. But I think it is important to note that there was payments being made to the town in relation to childcare services. They come in many forms. Intermunicipal services are those services provided by a municipality that benefit residents in more than one municipality. It's a pretty simple definition. Ernest Taylor provided testimony that ECDC is a service provided directly by the town to town residents that also benefit residents in the county. She also provided testimony on the operations of the facility. No issue was taken with respect to her evidence. The town submits, therefore, that ECDC is an intermunicipal service which ought to be included in the ICF. The fact there are very few municipalities which provide childcare services as a municipal service is irrelevant. Each municipality has different issues and priorities, and the provisions of childcare services falls clearly within the purposes of a municipality. Council has very broad authority to determine which services will benefit their residents and which services will be made a priority. And by being made a priority, it means which ones they're going to put some money towards. I absolutely agree. The ECDC is a decision made by one municipality that impacts another municipality. And yes, the residents of the adjacent municipalities do not have a say through the democratic process on those decisions. But the fact that council for the town of Drayton Valley is not answerable to the residents of Brazeau County doesn't mean they're not answerable. Council for the town of Drayton Valley is answerable to its own electorate, the electorate of the town of Drayton Valley. And that accountability applies not only to what services are provided at the municipal level, but also to ensuring that operating costs are minimized and revenues are maximized. The town of Drayton Valley also owes a duty to its residents to ensure that it's being fairly compensated for the services that's providing to neighboring municipalities. Back to ECDC. So once a municipality makes the decision to provide certain services and facilities, if those services and facilities benefit the residents of another municipality, then they are intermunicipal services, and the intermunicipal collaboration provisions of the Municipal Government Act require that the benefiting municipality contribute fairly and equitably to the cost of providing those services. It is relevant, it's irrelevant, I've said this before, how many other municipalities in Alberta have decided to provide direct childcare services. It is relevant that there is limited licensed childcare spaces in the region. The number of children who require childcare, the number of children significantly outnumbers the number of available spaces. That's information that was provided by Ernest Taylor. Now, I would admit that what is fair and equitable might change if a service was being provided for which there was no demonstrated demand for it. So if a municipality was to provide a service and there was absolutely no demand for it, I think that would be taken into consideration in determining what's fair and equitable. But that's not the situation that we have here with ECDC. We have a demonstrated need for childcare spots, and we have a municipality who's decided that from their perspective, that's a priority and that they're going to put some money towards providing those services. And county residents benefit from that decision. If we were to exclude services which one municipality voluntarily decided to provide, because ratepayers in the adjacent municipality cannot vote for the councillors who make these decisions, then no rural municipalities would ever have to contribute to recreation services or any services in an adjacent urban municipality, even when those rural residents are benefiting. The basis upon which that the town seeks contribution to ECDC is different than with respect to the recreation and cultural services. For ECDC, the town is seeking contribution that is directly tied to the actual use of the childcare services by the county families, despite the fact that the actual benefit to county residents is much greater. The availability of affordable childcare is a significant advantage that a municipality may have over another municipality or one community over another community. No issue has been taken with the operating expenses of the ECDC. No evidence has been put forward to challenge the numbers. The only issue raised was with respect to the federal $10 a day childcare subsidy, which Mr. McCary confirmed would not affect operating expenses and would only affect how much families pay. So that's all that I'm going to say today about ECDC. Getting on to the recreation and culture facilities, that's what I'd say the majority of the evidence that you heard over the last 3 days really relates to. With the exception of the Brazeau Sports Park, where there's ball diamonds and soccer pitches, all of the recreation and culture facilities are services and facilities provided by the town at a significant cost, which benefit the residents of the county. Through the agreed documents, the view that we did last Friday, and the evidence of Ms. Drayton and Mr. Olenek, we, I think, have a very good understanding of what the recreation and culture facilities entail, what they look like, and the high level of both the facilities and the services that are provided there. It goes without saying that the county does not have an arena, curling rinks, fitness center, pool, skateboard park, or splash park. Those are all facilities that within the 2 municipalities are only provided by the town of Drayton Valley and are only located in the town of Drayton Valley. I think you're probably pretty familiar with the history at this point, but it was in 2019 where the parties did have an agreement in place, which was still based on a 50-50 split of the shortfall in operating costs. Under that agreement, the town was paid $1,036,000 by the county, and the county was paid by the town $4,845. So pretty significant difference in the level of contribution that was flowing. It was in 2020 that things fell apart, I would say, a little bit, despite there being a total operating shortfall of about $2 million and a unanimous recommendation from the rec board to both councils, council for the town and council for the town at the county, to pay 50%, which would see the county paying the town $1,046,000. The county unilaterally, without any prior notice to the town, only paid $454,000 based on a per capita rate of $58.49 per person. That required the town in the final quarter of 2020 to absorb a shortfall of approximately $591,000. Exhibit 5 was entered during the hearing, and Exhibit 5 was minutes from the County Council meeting of September 15th, 2020. That would be the document to refer to, sir, where we see the 2 motions with respect to the transfer payment that would be made from the county to the town for 2020. The first motion that was made was one to make a payment of $83.43 per capita. That motion was not passed. The motion, which actually was adopted by council, was the motion that they would pay $58.49 per capita in lieu of accepting the recommendation of the Recreation Board. And I think it's worth noting, sir, that during that council meeting, Councillor Heinrich voted in favor of not accepting the recommendation of the Recreation Board, despite being a member of the Recreation Board and participating in the unanimous vote to make that recommendation to council. No comparable recreation and culture facilities are available in the region. That's the town's position. Not only are the facilities in Ponoka, Lacombe, Old, and Rocky Mountain House not comparable to facilities in Drayton Valley, they are an additional 1 or 2 hours away for county residents. No evidence was provided of the recreation facilities or services available in Ponoka, Lacombe, Old, and Rocky Mountain House, aside from the existence of twin arenas. With Ponoka, there was also some additional detail with respect to curling rinks and other amenities in their facility. There was no evidence on the actual distance between the various parts of Brazeau County, how long it would take to drive, and there was no evidence that that was provided to us as to the use of the facilities by county residents. So one would have expected, sir, that there would be evidence available with respect to usership of those facilities by county residents. None of that was provided. If county residents use the recreation facilities or services available in Panoka, Lacombe, Olds, and Rocky Mountain House, the county does not contribute any funding to these urbans. So there's no argument being put forward here that the county's already contributed to recreation facilities in other municipalities, so that should be factored in. In any event, the existence of recreational services in other municipalities does not lessen or diminish the benefit of the town's recreation and culture services to county residents. Whether county residents use the town's services or not, they benefit from their proximity, quality, and level of service. The evidence over the last 3 days confirmed that the county provides little to no recreation services to its residents. Sorry, I take that back. Provides little to no indoor recreation services to its residents, presumably because these services are most appropriately provided by urban municipalities in most cases, and because county residents can access those facilities that are available in the urban municipality. Presumably it's not because the county doesn't value them. But the county's decision to not provide additional recreational services or any indoor recreational services doesn't relieve the county of the obligation to fairly contribute to those services which benefit its residents. Even if a county resident does not use a specific service, either because it's not something that they're interested in, they don't want to go swimming, they don't use the arenas, their kids aren't in hockey, or maybe they decide they would prefer the running track in a different municipality and they would rather drive farther for that. That doesn't change the fact that the residents still benefit from the fact the service is publicly available in the region. I'll move on to the allegations of unreasonable expenses associated with the recreation and cultural facilities in the town. So the town does not dispute that recreation services are expensive. They are. Every municipality knows that.
I'm just wondering if I can have you just pause for a second so I can catch up.
Okay.
Okay, fine, thank you, carry on.
Okay, so as I mentioned, the town isn't disputing that recreation services are expensive, they're expensive. But there isn't any evidence before you that came out during the hearing that the operating costs for the town's recreation and culture facilities are anything but accurate and that they are not reasonable. Put it, colloquially, the costs are what the costs are to provide these services. We heard evidence with respect to operating costs, attempts to reduce expenses, increase revenues. We heard evidence about the collective agreement, and we heard evidence that no inappropriate expenditures were demonstrated. Exhibit 2, tab 19, is the Joint Ad Hoc Committee report that outlines in some of the attachments the efforts that were undertaken by the town to increase revenues and reduce expenses. Exactly the purpose of the ad hoc committee and the Recreation Board. We also heard evidence from Ms. Drayton and Ms. Thompson that the monthly financial statements and the detailed transaction level financial statements accurately reflect the revenues and expenses of the recreation and culture facilities. With respect to the Omniplex, Ms. Drayton and Ms. Thompson both confirmed that a portion of the salaries and benefits for the managers and supervisors, when they had a supervisor, so managers and supervisors who manage the Omniplex are allocated to that sub-function for Omniplex 1. And Ms. Drayton testified that there is a tendency for salaries and wages for all of the facilities in the building to be included in Omniplex 1. Because the space is shared and it is hard to track when work is done in one area of the Omniplex as opposed to another. So if you're cleaning the floors, you just keep going. But these are still proper expenses associated with recreation culture facilities. For the other facilities, Ms. Thompson explained how coding, allocating the revenues and expenses to the different facilities worked. Mr. Olenek confirmed how the allocation of employee time and employee equipment works for the parks. And that evidence wasn't disputed in any way. Questions were asked of the town's witnesses regarding 3 transactions in particular. 2 entries related to Mr. Eason's car allowance and the pool, and 1 visa statement related to the Omniplex. All of these were easily addressed by Ms. Thompson as the allocation of costs to the appropriate facilities. So we had 3 transactions out of thousands of transactions, out of hundreds of pages of detailed reporting, and they were not even improper entries. Aside from the 1 misallocation of an operating expense on the capital side, which we'll talk about in a little bit, which was caught by both parties and was remedied, right? No dispute. The county has pointed out no financial improprieties. The county simply believes the salary expenses are too high, which brings us to Ms. Tiffin, the HR director. She took us through the wages and salaries for the union employees, which is all but 2 of the employees at the Omniplex. As you know, when there is a union, the terms of employment are determined through the collective bargaining process, and the town cannot deviate from the collective agreement, which is the result of that collective bargaining process. The county has put forward no evidence that the union rates are unreasonable. That would mean challenging the collective bargaining process. And no evidence that the non-union salaries are unreasonable. In fact, we heard evidence that because you're competing with oil and gas companies, you're in a situation where you need to perhaps offer more to keep those employees. The county has also put forward no evidence that the number of employees working at any one time in the Omniplex, the level of service, is unreasonable, out of the ordinary, or unnecessary. With respect to that point, I would refer you to Exhibit 3, which is the Farmer Omniplex benchmark study, which demonstrated that the number of Omniplex employees is actually quite low in comparison to the other facilities. A significant amount of time during the hearing was spent on the surveys that were prepared by Mr. Chambers and their relevance to the town's operating expenses. The town's position that as they relate to the recreation spending in Panoka, Lacombe, Olds, and Rocky Mountain House, the surveys are not helpful from a benchmarking perspective because all of the facilities provide different amenities and services. All of the facilities are different ages and in different levels of repair. And all of the facilities have different employee arrangements. Well, we presume that's the case because the information about those factors with respect to the other facilities was never provided to the Recreation Board or the town despite request, and was not provided in the course of this arbitration. We heard evidence with respect to Mr. Chambers on his comparables for costs. While stating that he had to be forceful to have certain matters included in the minutes, he confirmed on cross-examination that any requests to include certain information in the minutes were granted, that the minutes were always approved at the next meeting, that there was the opportunity to make amendments to the minutes, and that he agreed all of the resolutions were properly included. He also agreed that the minutes from the ad hoc committee and the Recreation Board do not include any requests for information from the town that went unanswered. While stating that the county asked many times for detailed financial information in the direct, he confirmed on cross-examination that no requests are shown in the minutes or as resolution. Mr. Chambers also confirmed that despite the town asking for additional information with respect to the comparables, he never provided that information. So we have both municipalities alleging they asked for information that they were not provided. But neither of those positions actually help resolve the issues that are before you today. I'd submit, sir, that that's a bit of a dead end. Tab 9 contains the minutes from the ad hoc committee meeting of October 1st, 2018. So Exhibit 2, Tab 9. This was the first time Mr. Chambers submitted a chart of comparables. He confirmed that his chart was based on comparable populations in central Alberta area he was unable to speak to the population of Lacombe, which I would submit has a population almost twice the size of the town. He admitted that of the comparables he used, Rocky Mountain House did not have a union, and that he didn't ask Lacombe if they had a union. He admitted that Rocky Mountain House has a 50-50 sharing arrangement, cost sharing arrangement with Clearwater County with respect to recreation services. While Lacombe provided information that its salary expense included portions of managers' salaries, he did not ask the town if that was the case with their numbers. He did agree that the pools were pretty much in line and there was no issue there with the pool. And he indicated on cross-examination that he did not recall asking the town why their numbers were higher. Exhibit 2, tab 24 are the minutes from the rec board meetings, September 3rd, 2020. This is the second time Mr. Chambers brought forward a chart setting out comparables for the Omniplex. When we went through that chart together during cross-examination, Mr. Chambers confirmed that sometimes actual numbers and sometimes budgeted numbers were used, that he mixed actual and budgeted numbers. He agreed that actual is better than budgeted. Given the time frame, it's not clear why he didn't go back and obtain those actual numbers subsequently. He confirmed that the concerning difference with respect to the Omniplex was in wages and salaries. But he did not ask the town for the collective agreement, for the QP wages, which management positions were attributed to Omniplex, or any information about the management wages either, management salaries. At that meeting in September of 2020, he reached the same conclusion that the pool was in line. It was the Omniplex salaries, wages, benefits that was at issue. And again, no information was provided on the key attributes of those comparable facilities other than the presence of the two arenas and the additional detail with respect to Pinocchio. So while the town disputes that they were unresponsive to the county's requests for additional information about the operating costs at the Omniplex, even if that were true, it is not addressed by substituting operating expenses from other questionably comparable facilities and reducing the contribution. It is addressed through required reporting and a dispute resolution provision. With respect to the later pages in the second comparable report, which Mr. Chambers presented in September of 2020, the amount that other urban municipalities receive in recreation operational contributions is also not relevant to what is a fair contribution by the county, because every urban municipality provides unique recreation facilities with differing levels of service.
Thank you. Can I just get you to pause for one moment again?
I'll slow down.
Fine, thank you. Carry on.
So I was just making the point, sir, that when we're talking about how much other urban municipalities receive in recreational funding, that is also not a relevant consideration on what a fair contribution by the county would be, because every municipality provides different recreation facilities with different levels of service to different adjacent municipalities. For the same reason, those figures are also not a reliable indicator that the town's expenses are too high or that their revenues are too low. Those are totally unrelated. So we did hear evidence from Mr. Chambers with respect to the comparables on contributions to recreation services. Again, that's Exhibit 2, tab 24. He confirmed that with respect to those comparables, he chose based on proximity to the county. He did not choose those comparables based on comparable facilities or services. He confirmed that he didn't know what facilities and services were provided to those rurals by those urban municipalities. He confirmed that the selected comparables were not based on population, and that 4 out of the 6 had populations at least 50% greater than the county. He agreed the higher the population, the lower the per capita number. He agreed that his chart did not include all contributions made by those rural municipalities to recreation services that they benefit from. And he agreed that some of the rural municipalities were in the process of negotiating their ICFs and that no follow-up information was provided. Now, we also heard significant evidence over the last 3 days with respect to the 2 farmer reports. So the first farmer report is found Exhibit 2, tab 32, and that is the municipal inspection report that was prepared, released in 2016. The second farmer report is the Omniplex benchmark report, which was Exhibit 3. So the municipal inspection report prepared by farmer on page 51 was confirmed by Mr. Chambers that that report was not limited to just recreation spending, that recreation spending was one aspect of a 56-page municipal inspection report. It was only one of many concerns that were being reviewed by farmer regarding the operations of the county. Mr. Chambers confirmed that in the municipal inspection report, farmer identified 6 counties as benchmarks, or identified that he looked at 6 counties as benchmarks. He didn't identify the counties on the basis of population, not on the basis of amenities. Mr. Chambers also confirmed that while farmer concluded that the amount being spent on recreation cost sharing was higher than the average of the benchmark municipalities, he also concluded that the county was in a strong financial position and that the transfers were not a hardship for residents. I would also point out that he concluded that it was well within the authority of the municipality to make that decision. Mr. Chambers then confirmed that while the county was concerned about the town's operating expenses with respect to recreation facilities after the issuance of the municipal inspection report, he didn't do anything about it for 2 years. The first survey that he provided during the course of the ad hoc committee was about 2 years later. He confirmed as well that he did not contact farmer to find out which 6 comparables he used. When we look at Exhibit 3, which is the farmer Omniplex benchmark report, Mr. Chambers confirmed that the purpose of this report was different. The purpose of this report was to look specifically at the operating costs for the Omniplex. He confirmed that he was aware that it was being prepared by farmer and that he had the opportunity to speak to farmer about the report before it was concluded. He confirmed that he would have had the opportunity to express his concerns during that call, but he does not recall if he shared his 2 surveys with the comparables that he had brought forward. Mr. Chambers also agreed that the Omniplex benchmark report chose its comparables based on an equivalent variety of amenities as opposed to population. And I would submit, sir, determining comparables with an equivalent variety of amenities is a much more time-consuming process than simply identifying municipalities based on their population. And that may be one explanation for why in a municipal inspection report, where the recreation spending is just one of many issues that you're looking at, one would choose a quicker, faster way of finding comparables. Now, I would submit, sir, that the Farmer Omniplex benchmark report has some very important conclusions in it, which I would like you to be aware of. The first is that he does conclude that while the median average of per capita funding is very close to the median average, it is by no means inappropriate. So while he did conclude in the municipal inspection report that it was higher than average, in the Omniplex benchmark report, he concluded that the expenditures for the Omniplex very close to the median average, by no means inappropriate. But he also then went on to conclude that there is too much variation in terms of ownership and cost sharing agreements to reach any firm conclusions regarding a fair cost sharing model. And I think that's in line, sir, with the position that we're putting forward today, which is you need to look at the unique circumstances of the relationship between the two municipalities and the services that are being provided in order to determine what's fair. Now, the county seems to be arguing that the Farmer Omniplex benchmark report can't be relied upon because Mr. Farmer came to a different conclusion than he did in the municipal inspection report, that they're inconsistent. I would submit that there's a couple of considerations which were not addressed in that argument. The two reports were obtained for very different purposes. The Omniplex benchmark report properly looked at municipal facilities with similar amenities as opposed to basing it simply on population. If you only looked at population, sir, you could have an urban with a similar population with no rec center for some reason, and then the operating expenses would be zero in that circumstance. That wouldn't be comparable. And while there's not a lot of urbans out there that don't have a rec center, there are some circumstances where in fact the rec center is located in the urban directly adjacent to the, is in the rural directly adjacent to the urban municipalities. There are some examples of that. The MB of Greenview is an example of that. So the Farmer Omniplex benchmark report also came out 5 years later from the municipal inspection report, and it came out after ICFs became mandatory in Alberta. And once ICFs became mandatory in Alberta, that inevitably resulted in significant changes to the amounts being paid by rurals to urbans for intermunicipal services, in particular for recreation services. Now, it may be, sir, when the municipal inspection report concluded the county was paying more than the benchmarked municipalities in 2015, it was actually, and I would submit, it was actually paying its fair share all along. I actually think in this circumstance, Brazeau County was paying a fair amount then, unlike some municipalities that weren't. But the fact that it was fair then doesn't mean that it's not fair now. In fact, it probably supports that that amount is fair at this circumstance as well. So for lots of urban-rural relationships, it took mandatory ICFs to force the rural municipalities to pay their fair share. But what the county's been paying all along has been fair, and it continues to be fair now. The only one that wasn't fair was 2020. So in the town's view, the usefulness of comparables can be summarized as follows. For operating costs, comparables can be, at best, used as a check and balance. Comparables cannot determine what the actual operating cost should be. They can only be used to check if the actual reported operating costs are in the right range, but only where there is sufficient evidence to show that the other facilities are truly comparable, which is what's missing here. For recreation contributions made by other rural municipalities, it's our position that there are simply too many distinguishing factors for any comparables to be of use. How much one rural municipality paid to another urban municipality depends on too many factors. The intermunicipal services provided, the cost of those services, the benefit of the services to the residents of the rural municipality, because you can have circumstances where a recreational service in an urban isn't easily accessible by everybody in the rural. Therefore, the benefit doesn't apply to everybody in the rural. That's why we have this concept of catchment areas in lots of ICFs. Other distinguishing factors, the number of rural and urban municipalities which benefit from those services. So I'd mentioned before that I'd worked on the ICF for the town of Peace River and the MD of Peace. Peace River is a point where 3 or 4 different rural municipalities all join up there. They're at the corner of all of them. So you get into a situation where there are now 4 rural municipalities who are neighbors, who are benefiting from those recreation services. Okay, so the number of urban municipalities the rural contributes to is relevant. The stage of the negotiations between the rural and the urban with respect to ICFs is relevant as well. To be fair, some rurals negotiate a better deal in the ICF than others. So those are all distinguishing characteristics on how much other rural municipalities are contributing, which make it a not useful comparator. So we would urge you to give no weight to Mr. Chambers' survey with respect to the recreation contributions made by other rural municipalities, particularly the ones that he's identified. Now, with respect to the sharing of financial information, we heard a lot of evidence about that as well. The county's witnesses led evidence that the county has been excluded from financial information concerning the recreation and culture facilities, that the revenues are too low and the expenses are too high. We'll come back to this a little bit later as well when we discuss the appropriate level of financial reporting to the county. But for now, the town takes umbrage with the insinuation that the town requires oversight from the county in terms of administering its facilities. The town owes a duty to its ratepayers to provide good government, which includes fiscal responsibility, which includes transparency, and they have a duty to provide facilities and services that are necessary or desirable for their community. The town employs professionals and complies with the applicable accounting standards to require detailed financial reporting monthly to enable the county to independently verify all of the revenues, costs, and expenses of the facilities, including all of the revenues received and expenses incurred, not only undermines the autonomy of the town, but reaches the goal of efficiently providing intermunicipal services. There is simply no need for the county to double check the town's financials at a transaction level on a monthly basis. Town submits that through the ad hoc committee and the recreation board, the county has had full access to all of the town's revenue and expenditures with respect to the facilities. And should the recreation board continue, it will continue to have full access to the town's revenues and expenditures. I drew you to this in my opening statement, and I would mention it again here. It's Exhibit 2, tab 19. This was the report to council by the ad hoc committee in December of 2019, where they confirmed that the quarterly financial reporting provided a level of transparency and allowed each municipality to respond to its ratepayers on the value and optimization of tax funds. That report to council by the ad hoc committee, on which there were representatives of both the town and the county, is completely contrary to the assertions by the county's witnesses that they ought to have been receiving detailed transactions, that they were asking for detailed transactions, that they were refused, and that detailed transactions are necessary in order for the county to assess the accuracy of the requested contribution. That is the opposite of what that report to council said. We heard evidence with respect to the county's requests for information. Mr. McCary could provide no example for requests for detailed financial information and refusal by the town to provide same. Both Mr. Swap and Mr. Chambers acknowledged that requests for detailed financial information were responded to in a timely way once the request is made, and that there were no previous requests they could point to which were not responded to or were refused. Mr. Swap acknowledged that he did not ask Ms. Fancy's predecessor for the detailed financial transaction reporting, but once he asked Ms. Fancy for it, she provided in a timely way. We also heard evidence with respect to financial reporting by other entities. Mr. McCary testified that the county would expect the same level of detail from the town as it does from the village of Berwyn. Mr. Swap testified that he was not aware of the level of financial reporting the county provides to the town with respect to the Brazeau Sports Park. That didn't come through to him, but that the county does not have a separate sub-function for the Brazeau Sports Park. The purpose of this arbitration is to provide you with the information that you require to craft a fair and equitable ICF. And it's important to recognize that the dispute resolution provisions in the intermunicipal cooperation agreement, which has been in place between the parties between March of 2011, have always been available to the parties. Ms. Drayton testified that there have not been any steps taken by the county during that time to bring a dispute forward under the dispute resolution provisions, despite their evidence that since 2016, they have had these concerns with respect to the costs. The town is agreeable to an ICF agreement, which requires the town to provide the county with quarterly access to transaction level financial records for the recreation and culture facilities. That would allow the county to satisfy itself to the revenues and expenses associated with those facilities. In the event of a dispute, the dispute resolution provisions are available in the intermunicipal cooperation agreement. Okay. Now we'll move to exhibit to tab 22, which is the minutes from the Recreation Board meeting in June of 2020. So we spent a lot of time looking at that. And we heard evidence that it was at this meeting where Mr. Swap and Mr. Chambers brought up what they referred to as the double payment for capital costs. Mr. Swap confirmed it was not a double payment. They both confirmed it was included in capital and was paid by the county, $44,000. But once the error was raised by Mr. Swap and Mr. Chambers at the meeting, the error was acknowledged and the amount was refunded to the county. Mr. Swap confirmed the county had not been billed for or paid on the operations side yet. So it clearly was not a double payment. It was a payment that had been made with respect to the capital. And it was a change which was made based on the advice of the auditor, which both Mr. Swap and Mr. Chambers recognized as well. We heard evidence from Ms. Drayton that the misallocation had been caught by the auditors when they did the end of year adjustment and the town was going to address it, but Mr. Swap raised it at that meeting before they had an opportunity to speak to it. This refutes the county's allegation that without the detailed transaction reports, this would never have been caught. In any event, if it was an error, if it was a miscalculation, it was caught by both the county and the town, and it was fixed right away. And one cannot make the leap from the discovery of one error or misallocation that the town's operating costs are too high or that all of their financial reporting is somehow suspect. County has not shown any inappropriate expenditures to justify the level of oversight that they're seeking. The position advanced by the town, the monthly detailed transaction reporting, maintains the autonomy of the municipalities to provide the services and facilities they believe benefit their residents and to manage the operations of those as they see fit, without resorting to some formula that's completely unrelated to benefit. Now, what's been put forward by the county is a contribution based either on per capita or a fixed amount per annum. And that approach to contribution to operational funding would provide absolute certainty to the parties during the term of the ICF. they would be able to anticipate exactly what amount would be transferred. The problem with that approach is that it does not take into consideration the inevitable fluctuation in operating costs and revenues, which are unavoidable in facility operations. Both Mr. Swap and Mr. McCary went through the payments the county has made to the town for recreation services since 2011. And they're significant because recreation costs are significant. And we can see that the operating costs have increased since 2011. That is to be expected. We've also heard evidence, though, about the impact of an economic downturn in the region. And with COVID, we all know how quickly circumstances can change. A funding formula based on 50% of the operating deficit for the previous year is fairer and more equitable because it takes into consideration the benefit to the town's residents, the benefit to the county residents, and factors in the actual cost to the town to provide those services. Unlike with a fixed contribution amount, a percentage contribution means that any fluctuation in operating costs will be equitably distributed to those who benefit from the services. A fixed amount means, or could mean, that all of the fluctuation would be shouldered disproportionately by the residents of one municipality over the other. And it could go both ways. All right. Almost at the end, I promise.
That's fine, thank you.
So the county's witnesses also gave testimony, and I work with municipalities all the time. These are not things that I have not heard before on the financial challenges that the county's facing as a result of some provincial decisions. And these are difficulties that all municipalities are facing. So we also heard evidence that it's affecting the town as well. Some of the impacts are going to affect the county greater than the town. That's admitted. But some are going to have a more significant effect on the town than on the county. So in the county's rebuttal submissions, the county submits that it reduced its contribution to the recreation and culture facilities in 2020, in part because of downloading from the provincial government. Ability to pay is absolutely a relevant consideration in determining what is fair and equitable. But the reality is that the county did not prioritize contribution to recreation and culture facilities that its residents benefit from. The county has 3 times the equalized assessment of the town. That's an indicator of the ability to generate revenues and their ability to pay. The county rolled back commercial and residential taxes by 30% and has kept them at that level, giving them the lowest tax rates in the region, leaving about $800,000 on the table every year. And we definitely heard from the county's witnesses what the justification is for that and what the reason is and the approach that their council wants to take to taxation and leaving money in the pockets of the residents. And those are all fine and well, but that doesn't change the fact that there's the ability to raise revenues through taxes, and they've chosen not to do it. And the fact they've chosen not to do it cannot be a basis upon which contribution is reduced for services which fairly benefit county residents. Despite issues with linear assessment collection, and linear assessment is its whole topic unto itself with its whole language, believe me. Mr. McCary confirmed that the county's tax collection rate is still higher among other municipalities. Impacts on MSI funding are applicable to both the town and the county. The town has always contributed to policing, but now the county is required to do it as well. Despite these lost revenues that the county witnesses took us through, the county has maintained the lowest tax rate in the region. In addition to this, I think this struck a chord with me in particular because I do a lot of planning and development work. With respect to the fees the county changes, particularly in the area of planning and development, they've been charging $0 for services which would ordinarily be a few $100s in other municipalities. They may not have a lot of development in Brazeau County. That may not mean leaving a lot of dollars on the table. But if the only way municipalities can raise funds is through taxes and fees, it's taking one completely off the table. And then the last 2 points with respect to what's fair and equitable in the circumstances, I would take you to, I don't know the number of the agreed documents, but these are the pages from the county's website. They're at the end of the agreed document list, where there are, the first page on the county's website indicates that its economy is thriving. That may just be a case of promoting itself, I suppose, to interested parties. But also in the county press release with respect to the decision to maintain taxes at the same level for 2022, they made the statement they had found a way to keep services at the same level. The town submits that the county can easily pay its fair share of the intermunicipal recreation services that are provided by the town, but has chosen instead to offload an unbalanced share of these costs onto the shoulders of the town's residents. Now, sir, with just to a couple of the kind of additional matters which are addressed in our written submissions, but I just wanted to cover off to make sure that we touched on them today. The ICF agreement must be completed with notification to the minister by April 1, 2022. So that's the deadline that we're working against. You're obviously very aware of that, sir. It's the town's submission that the ICF agreement should be backdated to April 1, 2020, because April 1, 2020 is the first year there was no agreement in place between the two parties. And the payment that was made by the county to the town was a unilateral decision.
Why April 1?
Pardon, sir?
You say April 1, 2020?
Yes. Because the agreements, sir, the new agreement is required to be in place by April 1, 2022. Sorry, April 1, 2021 was when it was extended to. So we would.
I see what you're saying. I'm with you. I'm with you. Sorry.
And the agreement is in place, say from April 1 to the next April 1. It means that the payment is made the year after, sir.
Yeah, thank you. I'm with you.
So we would seek, sir, to have the agreement backdated to April 1, 2020. And that would include, sir, direction from you that we are seeking that the county would be required to pay the town the shortfall, if any, between what it paid in 2020 and what's required to be paid for 2020 under the ICF agreement. So there would have to be a adjustment there. I'd submit, sir, it's not clear in the county's submissions what they are seeking for the effective date and term. There are actually different dates and terms put forward in their initial submissions and their rebuttal submissions. Sir. The town submits the next review period ought to be 2024, regardless of when you commence the term of the agreement, not only to allow the ICF sufficient time to be properly evaluated by each municipality, but also to ensure that that it doesn't end in an election year. Because the difficulty if it ends in an election year is you're putting old councillors who are thinking about election time and new councillors who don't necessarily know what they're doing in a position where they are dealing with these kinds of issues, sir, which they may not be equipped to deal with. Now, at one point, sir, the county was seeking costs of the arbitration. The town obviously opposes that, sir. We would propose that the costs of the arbitration ought to be divided based on the proportional equalized assessment, which is the default that is provided in section 708 or 0.41 of the MGA. Both parties, sir, have come to the table to try and collaboratively deal with this. Both parties went to mediation. There's absolutely no evidence, sir, that one party was perhaps being difficult or dragging their heels or not being reasonable in trying to reach an agreement. Sometimes agreements just can't be reached.
Thank you.
So, sir, I've taken you through why I believe that what's being proposed by the town is fair and equitable in the circumstances, which facilities ought to be included, and responded to the concerns that were raised by the county. So that brings me to the end, sir. If you have any questions, I'd be happy to answer them.
I don't have any questions right now. Thank you. I think we should hear from Mr. Wilson, but I'm going to propose that we take 5 minutes before we ask Mr. Wilson to start.
Thank you, sir.
So we'll see you in about 5 minutes. Thank you very much. We'll reconvene. Mr. Wilson, are you ready to proceed?
I certainly am, sir. Always difficult to follow my learned friend in argument. Sir, in my opening statement, I told you that the county is looking for an ICF award that is equitable, is stable, and is predictable. That is what the county is looking from this process. And we are here today as a result of the Alberta government mandated policy to force ICFs on rural municipalities. During the course of the hearing, you actually heard my learned friend refer to rurals are going to have to pay more. She actually said that in the course of examining a witness. And before I go any further, I want the tribunal to be aware from 2011 to 2020, my client paid the town of Drayton Valley $8,032,369, over $800,000 a year. So to the extent that my friend was characterizing other rurals, I have no difficulty with that. But with respect to my client has been paying full fare, whatever the town has asked for over the years. So to the extent we're talking about somebody paying more, it would be my submission that the people who have been freeloading off the urbans should be asked to pay more. But with respect, with the exception of 2020, no one is talking about Brazeau County. Now, I can tell you that you heard repeated clear evidence from all of the witness that the county had concerns with the amount of money they were paying from 2016 onwards. Ms. Drayton, Mayor Dirksen, Councilman Ballas, and from Mr. Chambers and Mr. Swap with the county. The source of the initial concern is what I've referred to you, sir, as the Farmer One report. I make a distinction between the Farmer One report and the Farmer Two report because the Farmer One report was not commissioned by my client. I don't even suspect my client wanted the inspection report. The inspection is mandated by the municipal government, and the municipal affairs minister orders it. With respect, it looked to a wide variety of materials. Why Mr. Farmer was used, I have no idea. All I do know, he was not instructed by my client as to what to look to. So to the extent that we're dealing with Russell Farmer twice, we're dealing with Russell Farmer working for Her Majesty the Crown, and on the Russell Farmer 2 report that my friend marked as Exhibit 3, at the time I expressed my concern, and it's because I have to admit, I'm not a municipal lawyer like my learned friend, I'm a trial lawyer. An expert came into this hearing and testified without ever sitting down in the chair and being subject to what senior counsel when I was young, Mr. Brumlick called the crucible of cross-examination. Mr. Farmer on his second report would be asked whether or not he got Chambers' first survey. He would be asked if he got Chambers' second survey. He would be asked all sorts of questions about the comparables. And oh my God, why was it that you didn't use the benchmarking feature that's in page 51 of your first report? I have to tell you, as a trial lawyer, I would have been delighted to have Mr. Farmer come to the dance. But it wouldn't have been delight because there's something in the second report I didn't like. There are all sorts of things I'm going to make fun of a little later about the farmer's second report. But with respect, a party who has an interest in the outcome in this arbitration commissions a report. I don't do insurance defense work, but on a typical insurance case, the plaintiff gets an expert, and not surprisingly, the expert for the plaintiff has a high number, and the expert for the defendant has a low number, and the parties deal with that. Unfortunately, that's not what we're dealing with here with Farmer 2. And I apologize because I've jumped on Russell Farmer early, but it's again because of my background and trial experience. Because typically, where a document is marked as an exhibit and the witness doesn't come, it's a blank piece of paper. There's no writing on it. My friend made numerous references to Russell Farmer 2. I have to tell you, my friend also made fun of Mr. Chambers, including, I think it was Lacombe, because they have a population of 13,000 people. Mr. Farmer included Spruce Grove in a comparable with Drayton Valley, 7,000 people to 34, and Stony Plain, 7.2 kilometers away from Spruce Grove with 17,000 people. Now, Mr. Farmer also refers to his second report as a benchmark report. He doesn't refer to Lacombe or Pinoca or to Rocky Mountain House or Olds. And my friend then says, well, they're not comparable. They can't even be looked at. They're not even relevant. And at one point in time, my friend was making comments about there's no evidence somebody from Brazeau County goes to Pinoca or Olds or anything else. It's my understanding those communities were selected because of the size of their population, their proximity to urban centers, and the fact that they had a twin arena. And with respect, my learned friend is absolutely right. We're not here fighting over the pool. We're not here fighting over the skate park. We're not fighting over the tennis courts or I think it's pickleball or any of the other things. My client, since 2016, has had a concern with respect to the expenses that are associated with the Omniplex. We're not saying the pool's too high, the skate park's got too much concrete on it, somebody's doing something. There's none of that. And in fact, we've approached this arbitration. Both my learned friend and I committed to getting you an agreed set of facts. We committed to getting you an agreed set of documents. Not surprisingly, I had some concerns with the Russell Farmer 2 report, and I wasn't going to have it in by agreement. But with respect, the issue, I believe, in this matter is whether or not the expenses associated with the Omniplex are reasonable, are substantiated, and are fair. And with respect, I have to say, my friend, in summing up, suggested that quarterly reporting is more than adequate. It's okay. We don't need anything more than that. And with the greatest of respect, where my client is writing a check for $800,000 for an average over 10 years, it is not an onerous ask to say, can we see your math? And I have to tell you, the first time we saw the math, we discovered what we referred to as a double dip, and my friend is completely right. The second payment was not made by my client because, of course, the transaction was reversed. But it wasn't reversed because my client was wrong in making the allegation. It was wrong because we discovered it. That is, it looked like we were going to be charged twice. So to the extent that my learned friend has suggested, any sort of ICF in this matter need not have my client an opportunity to look at detailed transactions. I have to say, it would be my respectful submission that that is improper and unfair. I've mentioned it a couple of times. On August 6th, we had to apply to get detailed trial balances. You ordered it, and we received that documentation. My colleague, Mr. McLeod, examined Ms. Thompson, and Ms. Thompson took 13 minutes to produce those records and send them. I have to tell you, my friend is absolutely right. If I had to create and print off those documents, it might have taken 3 weeks, but that's my feeling. It was literally pull down a drop-down menu, hit print, and send it to my friend. So that's the labor involved with creating that information. And then my friend says, well, we're not even consistent in what we do. What does my client interact with Breton? What sort of accounting records are we dealing with? The amount of money dealing with Breton is $20,000 to $30,000 a year. My friend then says, what sort of a detailed accounting records do you have with respect to the Brazeau Sports Park? That's $6,000 a year. Again, average payment for 10 years from my client to the town is $800,000. I have to tell you, if somebody in my office didn't expense for $300, I don't care. I have to tell you, if he goes out for dinner with myself and somebody else and it's $12,000, somebody's going to have to answer for that. And I have to tell you, I'd want to see the detailed transaction. So with respect, again, no concerns with the expenses on any facility other than the arena. My client has had concerns since Russell Farmer 1, largely because he identifies the benchmark. He identifies what some of the other people are paying, and he identifies what we're paying. And I have to tell you, my client has some fiscally conservative, careful managers who look at that and are bothered by it. They are legitimately bothered by it, and it is something that continues. And what we have is in 2018, Mr. Chambers comes forward with what he thought was 3 comparables, and it isn't accusing anybody of anything. It's to say, hey, we're looking at this. Here's 3 other twin arenas. Why are their costs so low? And with respect, nothing happens. We don't have any magical exchange of information. And my friend does a masterful job of examining Mr. Chambers and Mr. McCary and asks, quite rightly, well, did you ask for this? And did you ask for that? And did you ask for that? We brought forward information that in the ordinary course, I would expect somebody would say, hey, our printer network is 65% higher than another law firm. Well, I have to tell you, my partnership would go crazy with that information. All they're doing is, we have a concern about expenses. We raise the question, and I have to tell you, we are told, sorry, we're unique. And I have to tell you, one of the things that is always raised is we have a union. Well, I know just a little bit about collective agreements and unions. The problem with the expenses at this location are not the union workers. Tab 4, Exhibit 4, Mr. McLeod's table which sets out what the charges are. We have in February a set amount of money that's charged for operating the Omniplex. We take the number of days in February, we divide the total by the number of days, and we have a daily charge. Mr. McLeod in Exhibit 4 for the month of February identifies 28 days and amount, and then we apply the lowest person who works at the arena and applies 8-hour shifts. And with the greatest of respect, I'm not suggesting for a minute you have the lowest guy in the arena running the operations. It's just for illustrative purposes. It is a very large number for the amount of 8-hour shifts for each and every single day for the month of February. And I remind the arbitrator, we're at the Omniplex on our view, and I asked the arena manager how much staff he had on, and for a busy Friday night with the Drayton Valley Thunder playing that night, he had 2.5 staff on. So when we look at the February averages for each and every day, either at the high rate or the low rate, on a busy Friday when the Drayton Valley Thunder are playing, we don't even come remotely close to that. So with respect, when my friend says, we have a union, the union isn't the problem. The problem is, what else are you charging? And with the greatest of respect, my friend made a comment about one of Mr. Chambers' tables referred to the Lacombe pool, and he has 3 or 4 asterisks, and at the bottom of the table, Lacombe pool tells you, we're charging you X so much of the full-time equivalent for this manager, and we're charging you this much for the guy that sweeps the floor, and we're charging you this much for something else. And with respect, we don't have that. We're told that the salary and wages is the union, which I'm saying is not the problem. And I have to tell you, the HR person repetitively told us, we're paying market prices. And I go, great. I may not be a proponent of collective bargaining and the union, but I have to tell you, on this site, my client doesn't have a problem with the union. It has a problem with the number we're charged for the month. Now, we did know from Ms. Thompson's evidence, which is why I ordered the transcript. Ms. Thompson said, in addition, we have the arena manager's salary. I have to tell you, sir, my client doesn't have a problem with the arena manager's salary. And the reason my client doesn't have a problem with the arena manager's salary is he's working in the arena. He's actually seeing that the ice gets cleaned, the ice gets scraped, the place is cleaned up, he's supervising stuff, no problem. Ms. Thompson also, and I have to say she stumbled a little on this. She wasn't sure if there was another supervisor, and it was timing. She didn't know if the person had left, had been there, had not been there. But with respect, again, that position was working and charged to the Omniplex. Now, if you wanted to ask me, what is the arena manager and the supervisor who may or may not have been working on the arena is a charge? Have no idea. We've double checked that information and we don't have it. We have the union, we have the union salaries, we have the total, and we've hopefully, helpfully laid out in Exhibit 4 how ridiculous it is that either the high or low people are the total charge. So with respect, when we look at the Omniplex, we don't know what the additional charges are. And it may entirely be people there working on equipment, maybe any number of things. But with respect, unlike Mr. Chambers' table that my friend said was not helpful at all, for the Lacombe pool, they actually identified the position and what portion of the position was assigned on a full-time basis to the pool. We don't have that. So when my friend says, and I keep coming back and bouncing on this, my friend says, we'll give you the quarterly documents. Well, that didn't give us the information. We get the detailed information, and we didn't get that information either. But with respect, my client wants to pay for the wages, the salary, and the benefits on the people who are working at the arena and the arena alone. So when my friend says we get the detailed accounting records and we look at it, and there is a difference of opinion. Ms. Dreesen's evidence was she told everybody what was there, and Mr. Chambers and Mr. Swab said no. We raised it, and it was confirmed at the meeting. I actually don't think all that much turns on who's right and who's wrong. But the first instant my client gets the detailed accounting records that doesn't have the arena manager's salary, that doesn't have the other parts, the other supervisor that Ms. Thompson referred to, we find an error. And I asked, my friend said at one point, you have to contextualize things. If you contextualize this, my client has concerns they're being charged for things that don't make sense. The first time they have an opportunity to check, they get a $44,000 reversal. Whether it was an honest mistake, I have no doubt. The problem is, when you start with the idea, we think these numbers are high, and the first time we get them, we confirm that, I have to tell you, there would be people with the fiscally conservative Brazeau County who go, well, what else is out there? And with respect, some of Mr. Chambers' evidence was that with respect, they got a bill for $120,000 for lawn mowing. Mr. Chambers, and it was in a summary report, wasn't even the detailed report. He looked at the $120,000 and he raised with the town that he thought the number was significantly too high for the services provided. And the bill for $123,000 was recalculated down to $53,646.25. So with respect, where my client is already anxious about the expenses, raises questions, and gets adjustments in its favor, Mr. Chambers comes to the meeting in the summer and submits the second survey, and it has 4 comparables. And again, my friend was going, it's a twin arena, it's near an urban center, and it's roughly, God knows Lacombe's larger than the county or Drayton Valley, not as big as Stony Plain and Sherwood Park, but that's Mr. Farmer's problem. And with respect, he lists a number of items, still doesn't question the pool. We're not, I readily concede we're dealing with the arena. And with respect, we then get a meeting, and my friend suggests the rec board meets, recommendation is for $1,046,000, and it's unanimously passed. Well, I have to tell you, politically, all sorts of people vote yes procedurally and no substantively. That is not out of the ordinary. The 2 members on council agreed that the recommendation for $1,046,000 goes to council and will be voted on. There's no suggestion that those people are bound to vote in favor for it. they get to go to council, and council, my friend is a great fan of autonomy when it deals with the town's autonomy, but with respect, the county has autonomy too. And two motions are tabled. I have to tell you, I sincerely wish the first motion was passed. And I believe it was $83 per capita, because it would be more reasonable. But I have to tell you, I have not been living 2016 to 2020, rating 800, 890, $1,039,000 checks and not getting accounting information. So the first motion is voted down, and the second motion is put forward for 5842, and a check for $454,584 is cut to the town. 9 months into the year, and there is no question, 9 months into the year would have been a shock to the town. But with respect, in the circumstances, my client, who looks at themselves as being an ATM for the town, keeps giving their checks, and any concerns they have, we bring forward two tables. The evidence is that Mr. Chambers has to work to get the tables attached to the documents. They're attached to the documents that are attached to the minutes that are in the agreed statement of facts. And with respect, other than attaching them to the minutes, no investigation is done. The town administration doesn't do it. Mr. Ballas doesn't do it. Mr. Ballas doesn't ask that it be done. The mayor doesn't do it, doesn't ask it to be done. And with respect, in September, the ask is, we're back. This year we want, I think it's $7,000 more than last year. And my client says no. And my friend at the start of during the course of the hearing says, well, rurals are going to have to pay more. With respect, my client has been paying a fair amount from 2011 to 2019, and in 2020, council autonomously decided they were going to say no. Now, with respect, my client is their policy of cutting their tax rate. As I understand it, the tax rate was cut in 2014 by 30%. And my client has kept that tax rate consistent through up until this year. And Mr. McCary testified as to what was behind it. And I think of the number of businesses in rural Alberta that see the price of oil go from $107 in the summer of 2014 to into the 30s through the last 5 years. And you're dealing in an oil and gas town. The county keeping my taxes low would be a pretty good idea. And it would probably be pretty proper or politically correct. I don't think that's what's behind the decision. I think it's a matter of what Mr. Swap said in his very capable and credible testimony. We do more with less. Everybody's doing more. And with respect, my friend then says, well, you're capable of paying. With the greatest of respect, the fact that my friend saves money for his retirement and I don't, my friend shouldn't subsidize my retirement. My friend is entitled to operate his business autonomously, his affairs. And with respect, my client has chosen to support its ratepayers and to keep its rate as low as possible. My friend in cross-examination asked Mr. Swap, well, why is it you're not taxing on development permits? And Mr. Swap quite properly said, we don't have a lot of development in Brazeau County. And I have to tell you, there hasn't been a lot of development in Alberta for the last 5 years. Because when your primary export is on its knees, not a lot of people are spending money developing businesses in depressed areas. Now, I'm sorry I got a little excitable there, sir, and I have to tell you, my notes tell me to go back to the Farmer 2 report. And all I'm going to tell you is, would have loved to have asked Mr. Farmer if anybody at the town, in the course of instructing him, told him about the comparables Mr. Chambers brought forward. And Mr. Farmer, if somebody told you about Mr. Chambers' comparables, I certainly hope Farmer 2 would then have a section where he said, I was told about Lacombe, I was told about Pinoca, I was told about Olds, I was told about Rocky Mountain House, and here is the reason why they're not comparable. And I have to tell you, if Mr. Farmer in Farmer 2 had that section, I would have had a lot less fun with Mr. Farmer. But we don't have that in the Farmer 2 report. And what does he have? He has 2,952 people in Athabasca and Spruce Grove. With respect, I don't care what hours they're open. I don't care what services they provide. With respect, they're not comparable in any way. So to the extent my friend says they're unique and can't be compared, with respect, don't tell me, just like your financial records, show me. Now, with respect, sir, I'm going to touch upon the ECDC, and I have to tell you, my client has not been asked to pay anything for ECDC, and it was not an issue until we got to this arbitration, and it was raised as part of the process. And with respect, we have over 300 municipalities in the province of Alberta, and it's my understanding a very small handful of them provide childcare. I have to tell you, neither myself or Mr. McLeod asked a single question of the ECDC director, because I have to tell you, I think that is an outstanding process. The idea of providing that service is outstanding, but with respect, it is not an intermunicipal endeavor, and it should not be something that is encapsulated, I would submit, in an ICF. You heard the evidence from Mr. McCary that our approach to ECDC or to childcare is to provide lump sums for home care. And my friend said, well, you give the check to us or to the town to distribute it to the home care. So long as the home care gets it, we're not providing the money to the town. So with respect, it would be my submission that ECDC is not something that we would do. Oh, Mr. McLeod has just pointed out to me, he did ask a question of Ms. Taylor. He asked her whether or not there are day homes available in the county, and she answered. So apologies, I misspoke. I can say that Ms. Taylor was not subjected to the Russell Farmer 2 cross-examination in any event. Now, with respect to the remedy sought, I have to tell you, I acknowledge my friend's expertise in this area, and she knows her stuff. My submission would be there should be ECDC should not form part of your award. It would be my submission that no retroactive funding should be provided to 2020. The only circumstance where I understood that took place was an agreement between Woodland County and White Court, where they agreed to have the matter be dealt with retroactively. There was a small piece of evidence that went in through Mr. Swap, and I'm not sure my friend or anyone understood the import of that evidence. Mr. Swap was talking about his personal experience growing up in the town of Drayton Valley, and he was talking about his friends who are county people who get picked up on a bus in the morning, are bussed into Drayton Valley, go to school, are there throughout the school day, and thankfully, they're then bussed home to wherever it is they live. And with respect, at the point in time they get off the bus at their home, they are subject to the mercies of their parents driving them back into town. And with respect, I can tell you, I would think it would be a little difficult to talk somebody into driving you in to go play pickleball or tennis or go to the skate park. And it's just the physical reality of students who are in the town from 8 a.m. until the school day, and then they're bussed to their home, wherever it might be. And those circumstances, it would be my submission to the tribunal that instead of a 50-50 split, the split be 40% of the operating deficit. And it in part is a recognition that they benefit from the existence of the facilities. They just don't use it to the same extent that town residents do. And in part, think of it, if you're 5 blocks away from the skate park and you're a skateboarder, well, first off, you probably have a head injury. But if you don't have a head injury, you go to the skate park and you skate, and then you go home. We're talking about county kids who are spread throughout Brazeau County and wouldn't have the easy access with respect to that. My client also would want to make sure that the award identifies that the salaries that are to be captured by the expenses for the Omniplex are salaries payable by the county are only those incurred as a result of employees actually working at the relevant facilities. Again, I say we take no exception with the arena's manager allocated to the arena, provided it's at market rates and that the salary is disclosed to the county. And that the expenses are those only incurred as a result of the operation of the relevant facilities. What my client is concerned with is the offloading of management salaries into the recreation and cultural area, which we say certainly looks like it's encompassed in the Omniplex expenses. And we wouldn't want your order to result in those expenses being offloaded to the pool, the tennis courts, etc. The idea is if you're working there, it's a legitimate expense associated with the process. You're not offloading management fees onto recreation and culture facilities you're seeking to have me pay. We would seek a detailed general ledger reports for every facility that identify at the transaction level all costs, expenses, and review. Now, my friend referred Mr. Swap to the section in the, I think it was the 2018 agreement, as to what information had to be disclosed. Mr. Swap's evidence, and I have to tell you, I thought it was very credible, was that he thought that description in the document would be detailed general ledger reports for every facility. It deals with a breakdown of wages, including the allocation of any and all non-union salaries. We believe that also with respect to this arbitration, that the arbitrator should deviate from section 708.41 of the Municipal Government Act we think that the arguments that have been advanced to you are all legitimate. Respectfully, the evidence shows that the county, unlike other rurals, has been paying its fair share from 2011 to 2019, and in 2020, they decided to stop. Those are subject to any questions you might have. My submission, sir.
Thank you very much, Mr. Wilson. I do have a few questions, perhaps just for you, but also Ms. Becker-Brooks, arising out of both of your submissions. The first question, and I'll ask you first, Mr. Wilson. What would you have me do with Exhibit 4? Like, what am I supposed to draw from Exhibit 4?
Well, sir, I'll be as upfront with you as I can. In the course of examining Ms. Drayton, I told yourself and Ms. Becker-Brooks to bring your calendar. And in the course of pardon me? Calculator, sorry. In the course of her evidence, she indicated there were additional charges made, and a decision was made to not ask her those questions because, of course, the director of finance was coming next. And we looked at it, and the tables were ready. The Exhibit 4 was ready to go, but having regard to the evidence, the choice was made to ask the director of finance. And the director of finance's evidence was to identify one position, the arena manager, and possibly a second position. And I don't remember right now what the name was, but she wasn't sure what it was. And we didn't have the arena supervisor's salary provided to us. We didn't have the other person's salary provided to us. And Exhibit 4 is just to show you that the union and the fact that they are unionized staff is irrelevant. There is no possible way they are having every day in the month of February 7 senior people working every day. It ain't happening. And it's no more than that. It's that coupled with Thompson's evidence that there are other salaries, which we don't have. Because if my friend wants to say, no, it's just unionized staff, the math is in front of you in Exhibit 4, no more than that. And I will say, Ms. Thompson verified the monthly amount, the lowest paid employee, the highest paid employee. And I have to tell you, the person who thought there were only 30 days in January was me, not Mr. McLeod. And I'm not saying I got a little egg in my face on that one, but it was me, which is why I'm talking about February. And the math is just that simple. It is, if on a Friday night for a Drayton Valley Thunder game, they have 2.5 people on, how do you get 7 supervisors?
Well, thank you. That helps me a lot. I don't think I need to hear anything from Ms. Becker-Brooks on that question on Exhibit 4. But
if you don't, I hear you.
Unless you'd like to say something, I'm happy.
I would like to say something.
Then please do.
What I would point out is that if we had known that chart was going to be created and that calculation was going to be done, the town would have had the ability to absolutely bring forward, these are exactly who was working on those days. Like we have that information, obviously, but that wasn't information that was requested when documents were requested, and it wasn't a document that we had ahead of time. And it was actually a document then that was put to Ms. Thompson And Ms. Thompson is sitting in her office as the finance person receiving these numbers. It would be Ms. Drayton who could say, well, in 2019 on, during the month of January, this is how many people worked at a Drayton Valley Thunder game. And this is how it compared to you doing a tour on a Friday afternoon in 2021 when we're just coming out of COVID. Like we would have responded on that basis. So I think it should be taken in recognition of that fact.
Mr. Wilson, I have a question for you. In your written submissions, I think the main remedy the main alternative you were pushing was for a fixed lump sum contribution, as opposed to contribution based on a percentage of an operating deficit. Have I got that right?
Yes. And I have to tell you, to be fair to my friend, she identified the pros and the cons to that. My client with a lump sum gets the benefit of certainty. My friend gets the benefit of inflation or deflation. And I have to tell you, if it's deflation, I suspect next year my client's mad at me, right? Like if we paid $100,000 and the actual number is 740, she's just made a bunch of money.
Technically, I would make.
Yeah, and I also can say, and I want, this is my pet peeve about this entire process, and it's my pet peeve. The way the ICF process is set up is the host is trying to get more money. And to the extent my friend says we're collaborative and cooperative and everything else, and it may just be me, I think there's an element of combativeness involved. But I have to tell you, you wanted to make it as fair as possible. You would set the number, and then the party who is asked to pay can either run the facility or write the check. Kind of like a corporate shotgun. Well, my comment, the town wants as big a number as possible. And if you set a large number, I'd like to then be able to raise my hand and say, you know what? This year we'll run it. Send me a check for $1 million too. And I can tell you that is not the way the legislation is set up, and it's not your mandate. But with respect, that is the process we have.
Give me a few minutes. If I were inclined to order a lump sum that is not tied to a percentage of an operating deficit, what would be your submission as to the lump sum that I should order, Mr. Wilson?
Well, if we were dealing with 2021 forward, excluding my friends seeking retroactive, I would submit a sum of about $700,000 would be appropriate. And I have to tell you, sir, I made submissions that it shouldn't be 50-50 because of use. We do get a benefit from it, but our kids are long gone for the great majority of the 24-hour day. And 50-50, I will say 2007, the agreement was based upon tracking use. And because data was not available, they went to 50-50 because that's the school population. Well, I have to tell you, in South Korea, when COVID hit, they're tracking 35 million people on a Friday after a Monday. That's how long it took them to track it. So if we were using use data with respect, I suspect the numbers would be a little different. 40%, and I would submit $700,000.
And help me with that math. The 40% comes, 50% is a million and change, 40%
Well,
is less.
Well, there's the problem with Canada is everybody plays hockey. And I have to tell you, if you get bused home, one of your parents or a neighbor is going to pick you up and drive you to the arena. I don't say that anecdotally. I am telling you that's what happens. I also can tell you that doesn't happen with the pool, and it's not going to happen with Johnny saying, I want to go to the skate park, or people our age saying we want to go play pickleball. But I say 50-50 is a slightly inflated number. So I say 40%. And then I look at the $1 million shortfall. And I again go back to this, sir. I don't know what management salaries have been offloaded on the arena. And I'm not talking about the arena manager. I can't say this enough. He's working at the arena, getting things done. It's the other people that I'm talking about. And I do think there's an attributed number to that. So to the extent that the attributed people are withdrawn, those are the numbers I would submit are appropriate.
Ms. Becker-Brooks, if I were to go the route of a fixed lump sum, I'm not saying I'm going to do that. Do you have a submission as to what the number should be?
If you're going with a fixed lump sum, the numbers that have been put forward by my friend would work out, $700,000 would work out to about $95 per capita based on the math we've done on this end. I would submit that that continues to be lower than what would be appropriate in the circumstances, because it would only see less than 40% contribution to the actual costs of the facility. I also note that the 700,000 is in line with what would have been the contribution by the county a number of years ago, and doesn't take into consideration inflation. So I don't necessarily have a number that I would put forward. If you're going with a lump sum, I can tell you that the 50-50 number from 2019 resulted in about $137 per capita. That's where it landed. Now, my friend has also suggested that going with something like 40%, taking into consideration that he would submit anecdotally, or we can assume, I guess, that there is less uptake by the population in the county than there is by the town. So making an adjustment to recognize that fact. Not saying that I agree with that, but if you accept that proposition, the 40% based on the current numbers would work out more like 107,000 per capita. And if you were looking at going with a lump sum or a per capita amount, I would say that that is more in line with what the town would be looking for. But we are still of the view that sharing 50-50 is what is fair and equitable in the circumstances. And maybe I'll just take this opportunity. When I indicated that rurals are going to be paying more, I didn't mean the county. I followed that up by saying, you know what, the county's been paying fairly. Our position is that they need to continue to pay fairly.
Yes, yeah, I noted that you were not suggesting that the county hadn't been carrying its weight prior to 2020. You were saying they were paying fairly.
Yes, sir.
Prior to 2020. Now, if the award is based on a net operating deficit or the total operating deficit, I take it that I'm to use the number in paragraph 31 of your agreed statement of facts. That the total operating deficit is $2,092,282.43.
Well, sir, that number would be, that would be the 2019 numbers, sir. So those numbers are there for the purposes of you having a set of numbers to look at. If your award was to decide on a percentage of the net operating costs, it would be based on, we had proposed based on the previous year's net operating costs. I suppose it would be open to you, sir, to say the average of the previous 3 years, or a 3-year rolling average, or the number 5 years ago. Like you would be able to use as your reference point, I suppose, whatever combination of operating costs that were incurred. But those 2019 numbers are the numbers for 2019. They would be different in 2020. They would be different in 2021.
Okay, but if this ICF is effective April 1st, 2020,
then it would be the 2019 numbers for 2020, based on what we've proposed.
which is that number in paragraph 31.
Yes, sir.
Okay, and I appreciate that I could, in theory, say it should be based on a 3-year average or whatever, but I'll direct this to both council, I guess. One of the things I'm not clear about is what is the status of the recreation board at this time? I think I heard a throwaway comment sometime yesterday that the 2 members of Brazeau had resigned from the recreation board. Is the recreation board still in existence? Does it carry on? Is it defunct? What's the status?
The Recreation Board continues, and that there are still bylaws in place for the town and the county, indicating that we have a recreation board and these are the people who sit on it and these are the terms of reference, and this is what it looks like. Subsequent to the county making the unilateral decision to reduce its funding, the 2 members of the recreation board from the town resigned, but the board still exists.
Sorry, the 2 members from the town resigned?
Yes.
Okay, and are the 2 members from the counties, they have not resigned?
I don't believe so.
Okay, and the town has not appointed anybody new?
Hasn't yet.
But going forward, one of the options is to keep the recreation board, try to utilize the recreation board to the extent possible.
Yes,
Is that fair?
that's available, sir. Yes, the board continues to exist. And if there were certain obligations or responsibilities that the board had, then presumably the town would have to then appoint 2 members. They would be appointed by council.
And I'll address this to both sides, I mean, my impression of this is that the recreation board and its predecessor were doing good work, and that it was helping. So I'm inclined to want to keep that happening. Do the parties have any strong feelings one way or the other about that?
I have to tell you, the idea of having a venue where you can come forward and make your concerns known is positive. And I have to tell you, I'm not sure, I'm delighted my people didn't quit, but I have to tell you that I think the breakup in 2020 has solidified people in certain positions. And I'm not sure that's a positive.
Oh, exactly. That's the difficulty I see here is that, I mean, I think one of the witnesses testified that, you know, the board was making progress. They came up with their September 2020 motion, which among other things said, we got to keep investigating a whole bunch of things and we got to go evaluate arenas, all of which seemed very reasonable. But then the whole process got sidelined by the motion of council. And since then, I'm taking there hasn't been any appetite to restart the processes.
I don't think they've engaged.
But so that the town is supportive of the board continuing.
The beauty of email, sir, I can tell you that I've been told that the county is in favor of the board.
Okay, I want to revisit something we talked about briefly at the end of yesterday, and that is your working on the agreement between the two of you. It seems to me we should be setting a deadline by which you give me what you've agreed on and your positions on what you haven't agreed on.
I'm wondering, sir, and I have to tell you, I'm working off a template my friend gave me, but I'm wondering if we can't agree on something by X, we both give you what we would propose to utilize. I wonder if that would work.
That's what I had in mind, yeah. Kelsey?
I think that that's reasonable. And I think it can be pretty short because it would just be a matter of coming back to revisit the areas of disagreement that were right before before the arbitration hearing commenced and see if, I guess, at this point in time, the parties' positions have changed on that. And if they haven't, I think it would be straightforward for us to each provide you with our proposed form of order, or not proposed form of order, but proposed form of agreement.
Okay.
Which are very similar except for like two clauses, basically.
And what timing would work for you in that?
I would ask that it be no earlier than Wednesday of next week. It's just, I will have an opportunity to seek and obtain instructions by then.
That's fine with me.
Okay, so does Thursday work then? Or,
Wednesday or Thursday.
okay,
The key, sir, is Tuesday.
okay, so we'll say the end of business on Wednesday.
Sure.
So by end of business on Wednesday, we're either providing you with an agreed upon form or we're each providing you with our proposed.
Yes, thank you. Okay, thank you very much. I don't have any further questions.
I'm just delighted my microphone worked today.
Yeah, you should have had that microphone the whole 3 days.
It's this room, sir.
Well, I want to thank both council or all council, Mr. McLeod as well, for running an excellent hearing and for their cooperation throughout this whole process. All council are highly skilled, and that was evident in the efficient way that we ran the hearing. It was very helpful to me. So thank you very much. I will endeavor to get my decision out just as soon as I can. If there's nothing further, we'll adjourn the hearing.
Thank you, sir, and thank you, Madam Reporter.
Thank you, sir, and thank you, everybody. It went pretty smoothly. I agree.